Garden State GSCLE. 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 Garden State GSCLE.
Now, 39.3-4 provides a statutory remedy to the police where they can actually tow the vehicle away, and that has a good part and a bad part. The bad part is it really kind of diminishes the idea that there was exigency associated with this. When the vehicle was never going to be left on the street, it's going to be towed away someplace and presumptively be in police custody the whole time. So it's hard to make an argument that there was exigency when the vehicle is going to be towed away, if that was in fact the police idea. Again, you can't have an unregistered vehicle on the street. It's just the statute 39.3-4 gives the police the authority to tow the vehicle. They also may have a policy for, you know, property that they've impounded that calls for, what do they call that kind of a search? Inventory search. In other words, they might have an SOP that lets them go through and search these vehicles in order to protect the municipality. What's the mythical municipality that we're saying exists? Cliffside Park?
That would be Cliffside Park.
It would be, or it should be?
It could be.
The police there may have a policy, an SOP, that every time they impound a vehicle, they inventory the contents of the vehicle in order to make sure it gets returned to the proper possessor, to present, you know, to get anything that's dangerous out of the vehicle, to make sure that the township's going to be immunized from false claims of sabotage or theft or things of that nature. You know, if they discover something during the search, that's perfectly fine. Remember, this is not a search for evidence. It's more like a community caretaking type of search. Or the police could just bypass all this stuff and ask for the guy's consent. Okay? Now, keep a couple things in mind. When the police ask for consent and they get consent, the scope of the search is really a function of the authority given by the consenting individual. Once the police have consent, they can search as thoroughly and as cautiously as if they had a search warrant. There's no distinction there. Just like the search warrant authorizes the parameters of the search, the consent authorizes the parameters of the consent search. So there's really no distinction between a search warrant and a search that's done by consent. The police can be just as thorough. The difference is that when you're dealing with consensual issues, consent can be transitory in the sense that the person who consented can withdraw his consent, can limit the scope of the search. What was that thing you were talking about, the kid was telling the cops where to search and not to search?
Oh yeah, I had a kid. I went up to the Supreme Court. Joe Rea wrote the brief on it, State versus Williamson, and my kid, when he was pulled over on Route 80 by a trooper for failing to signal when changing lanes at 1:30 in the morning when he was the only car on the road, the police officer just saw he was an out-of-state kid. He's heading back to Ohio. He figured that maybe he drove out here to buy drugs. Maybe there's drugs in the car. Lucky guess, there was. And he says to the kid, he says, "I'd like to search your car. Would you give me? You have the right to refuse. Would you give me consent?" The kid says, "Yeah, I'll give you consent. You can search my car anywhere but the trunk." Why even bother with the interior? Cop just goes, trooper just takes the keys, goes to the trunk. There it is. I said, anywhere but the trunk.
But that's actually, that's totally legal. And if the cops want to search, that's fine. The consent does not extend to the trunk. They don't go to the trunk, okay? But of course, the police they have their ways of dealing with these things. What they want to do is have complete access to search every aspect of the vehicle. Now, the consent has to be freely, voluntarily, and knowingly given. I've given all of you a consent to search form, which I guess is authorized by the county prosecutor in Mercer County. So let's just take a look. Everybody has his own copy? All right. Anything that starts with I immediately want to say, want to rock and roll all night and party every day. They should actually put this as part of the affidavit.
Well, you're always thinking that, even if you don't say it.
I, Joseph P. Rem, Jr., hereby authorize Officer A and B, police officers of the Lawrence Township Police Department, to conduct a complete search of this is going to be vehicle, located at, and they'll put the address down. And this permission is being given to me to the above named officers voluntarily, without force, fear, threats, or promises of any kind, being fully aware of my constitutional right to refuse a search without a warrant. It is further authorized that the above officers may take from my, whatever it is, letters, papers, materials. They should say house, papers, effects, but they don't. Letters, papers, materials, or other property which they may desire upon a written request. Signed and dated, witnesses which will be the cops, all right? And this form is in various iterations around the state. I have to tell you that the scenario I've given you has become, following the publication of the Peña-Flores decision in 2009, this is the SOP for the state police. They don't bother with these, automobile exceptions. They don't bother with getting search warrants. Their searches in these types of situations are almost always done by consent, okay? And they're really good at kind of getting these people to give their consent. These are highly fact-sensitive cases. And Joe, I wanted to ask you, what are the things that you look for when you argue motion to suppress on this in terms of rebutting the admission here by the guy that this was done without fear, threat? Well, what are the words that they use? No force, fear, threats, or promises of any kind. That, coupled with the ability of the defendant to terminate consent, withdraw consent, limit the scope of the search. How do you handle this as a defense attorney?
Well, first of all, I look to see if the form has in it the critical language, and I'm doing this voluntarily, and the loaded, cocked gun pointed at my head is not having any effect on my decision here. But in fact, that's what you really feel like if you're on the highways. You feel like there's a loaded cocked gun pointed at you because, the Supreme Court in one of their cases, I'm afraid I can't remember what it is.
Cardi. State versus Cardi.
No, there's a different point. It maybe came.
Cardi says, the one says that everybody thinks that he has to consent.
Well, yeah, in the case that I'm thinking of, they gave a list of reasons why guilty people would give their consent, because the argument's frequently made, obviously I didn't give my consent, they made this up, they signed my name, I mean, I knew I had a kilo of coke in a trunk, why would I give my consent? And the Supreme Court said, listen, there's a bunch of reasons why guilty people give their consent. People who know that they're guilty and they're carrying contraband, and among them, and I wish I could remember all of them, were probably 7 or 8, they were really good, but among them were, they feel that if they say no, they'll look guilty. Mm-hmm. B, they feel if they say yes, you can search, the police will say, well, since he's given us consent to search, obviously there's nothing in the car, why waste our time? Those were the two main ones, and I'm sure that's what most people think.
My favorite one is the cops will never find this unless they got a dog. They'll never find it. It's too well hidden.
Yeah, that's right. And of course, it may well often be too well hidden because we only get the ones where they find it.
Yeah. And also, you know what, Joe, too? Sometimes these guys are actually innocent in the sense that they don't know that the contraband's inside the vehicle. Sometimes they legitimately don't know. That happened a couple times in the history of New Jersey.
And hopefully in Monday in Ocean County, I will convince the judge that's what happened in my case.
So how do you handle these things, Joey? What do you do?
Well, the difficult part is to transport the judge to the scene because the judge is hearing it at 10 a.m. in a well-lit courtroom protected by sheriff's officers where there's joviality and professionals and secretaries and it's in daylight in the middle of a center of a city. Your client is stopped at 1:30 in the morning. He's all alone. There's not only one state trooper usually standing over him. He calls for backup because we know what happened to many troopers, Trooper LaMonica and others. So there'll be backup, and there may be 2 or 3 state police cars around you, and they all have the overhead roof lights on. There was once on the TV news shows 2020, John Stossel did something which is very interesting. It was about police chases, and but I think it's relevant to this as well. And in it, he got into a police car as a passenger with a police officer, and they drove around the big oval track 2 or 3 times at about 70 miles an hour. And his heart rate went from like 66 to like 72, okay? And because they're going around this track, and his heart rate went up to like 72. And then the officer says, okay, I'm going to drive the exact same track at the exact same speed, but now I'm going to put on the roof lights and siren. So they went around the track twice with the roof lights and siren on. His heart rate was over 100. Just the adrenaline flow from those sirens and those roof lights being on just gets you revved up. And that's true with people that are pulled over at the side of the road. You're standing there, you're naked against the world, so to speak. You're all alone. You have well-armed troopers around you. They have walkie-talkies that are squawking, and that's terrifying. It's black. black as night out. Tractor trailers are going by you, 6 feet away, and you feel the wind blowing them. You're outnumbered. You're scared. You're trembling. Like in a DWI context, you're then asked to, put one foot in front of the other and stand on one leg. Meanwhile, you're so scared you can barely stand up, much less perform this field sobriety test. The problem is trying to transport the judge, the trier effect, to that location that night to find the inherent subtle pressures that you're under. Not necessarily what the officer say, the trooper says, but when he stands over you and he says, "Now, sir, I have a form for you to sign," you're terrified about saying no. You don't want to offend the officer. Not that you think he's going to shoot and kill you, but you just think something really bad. He's going to be angry, and as a result of that, he's going to write you a slew of motor vehicle tickets, or he's going to do something to get revenge on you because you don't cooperate. Now, I'm sure that on occasion that happens, an officer in a bad mood, but for the most part that doesn't happen. But that's the subjective, maybe unrealistic fear of the defendant. How do you convey that to the judge? You prep your client carefully. You ask him without leading questions in your office, what were you feeling that night? And he'll recount all of these things. And then you go into court and you have him testify to all that. And the judge hears that and takes it into account in his decision.
And then denies it.
Well, I didn't want to say that. We have judges present
Joe,
who frequently grant them.
I have a completely different approach to this. I take the position my client's testimony is utterly worthless. Even if it's true, it's worthless, and nobody's going to believe it. He has such an interest in the outcome that I'm not going to waste my time. These are highly fact-sensitive cases based upon the totality of the circumstances. I like to rely upon circumstantial evidence because it really lets you draw inferences without getting into credibility calls. So one of the first things I'll do is I'll look at the consent to search form, and then I'll look at my client's regular signature. And when I see really sloppy handwriting, barely discernible handwriting on the consent to search form, that's a clue. The clue is he signed it while he was handcuffed behind his back, all right? Or he might have been inside of the police car when they signed it. Now these are very, very important details to bring out on cross-examination, because if the guy's got he's signing a consent form with hands handcuffed behind his back, okay? Presumably he was under arrest at that point. I mean, unless the police were handcuffing because they thought he was some type of a flight risk or dangerous in some way. That's evidence to suggest that there's something going on here that was coercive. If he's in the back of a police car, not only is that coercive, but how is this individual supposed to be able to withdraw his consent if he decides to, or to limit the scope of the search? Things of that nature. You see what I'm saying? Again, these are fact-sensitive cases, but circumstantial proofs will sometimes allow you to argue against the requirement that the state demonstrate that it was voluntary, knowing, and all those other things. Be mindful of the fact that it's not enough that it was voluntary or knowing at the inception. Remember that the defendant has an opportunity anytime to withdraw his consent, anytime until the police find some type of contraband or criminal evidence, something of that nature. By then it's too late, because their search at that point is going to continue on under some other exception, the warrant requirement, usually the automobile exception.
And Bob, I have found that...
Do you agree with me, Joey, in terms of the value of the
I think that's great. Certainly all the factors that I was enumerating, I almost never put the client on. Those are the things I want to cross-examine the cops about.
Right.
Did you have your overhead roof lights on? How many troop cars were there? Did you have walkie-talkies? Were they squawking? And, were you wearing a gun? And did you have a flashlight?
Which year did you have, which of my clients did you have your gun in?
But they have, here, the state troopers, and maybe locals, maybe they're trained, maybe by experience, maybe whatever it is, before they have my client sign the form, they ask them a question. And this is devastating, because I think it's coercive. Judges usually don't, but I do. They say, before they give them the consent form and explain consent, they say, "Excuse me, sir, do you have anything to hide?" Now, what's the client going to say? He's going to say, no. Once he says no, he knows that the logic dictates that he must then consent, because otherwise he would be seen as a liar, and he doesn't want to be seen as a liar. So if they say, "Do you have anything to hide?" he's obviously not going to answer yes, even if he does. And if he answers no, he feels innately compelled to act consistently with that denial by signing that consent form. And I think that's inherently coercive. I've convinced some judges, but not most. And after that, I think it's a done deal. That my client has no free will after that to say no.
If the police have a reasonable and articulable suspicion that there's drugs in the car, and they want to call dogs, that's perfectly fine. They can detain the individual for investigative purposes.
It's a valid statement of information.
I mean, when they say they're going to do that, there's nothing wrong with that. But then, if you're going to call the dogs, all right? If the dogs hit on the car, that's going to give you probable cause, and then you can either use the automobile exception or get a warrant or whatever you're going to do. But when you obtain consent by saying you're going to call the dogs, you know, the argument, and none of this is a matter of law, these are all factual issues. There's an argument you can raise there that it was coercive. You know, that the consent was not given freely and voluntarily, but it was coerced from the defendant by the threat of bringing these dogs in, okay? Remember, there's nothing wrong with the police bringing the dogs if they have a reasonable and articulable suspicion. The problems start when they switch from that to they recover the drugs as a result of a consent search.
Especially when you're hiding the drugs in cans of Alpo. You know that the dogs are going to alert. Oh my God.
Again, but by the way, when you're talking about a reasonable or articulable suspicion, you know, you're talking about a tiny bit of proof, a little bit less than probable cause, okay? So they don't need a whole lot, but to get the dog search going, that's what they're going to require. Now, a couple little housekeeping details. As again, I've said 1,000 times, these are highly fact-sensitive questions, credibility calls for the judges to make. The standard is the totality of the circumstances, not one little thing, but all the factors confronting the officer who's making these determinations. There is an enhanced burden of proof in New Jersey on consent searches. Typically, in the motion to suppress evidence, the burden of proof is proof by preponderance of the evidence, civil standard. There are 3 exceptions to that. The main one we're going to be talking about now is consent. Consent searches require proof by clear and convincing evidence, this enhanced standard of proof. And we'll discuss why that is in a couple of seconds. Just for those of you who are scoring at home, the other 2 exceptions are inevitable discovery and, let me see, what's the other one called? Collateral, I was going to say collateral estoppel.
No, collateral.
Collateral something. Collateral source.
That's
see?
it.
You know your evidence. That's collateral source rule. Those are the 3 exceptions: collateral source, inevitable discovery, and consent. The one that's going to come up all the time, though, is consent. So be mindful that when you do this, that the burden is going to be on the state to prove the facts of the case during the motion to suppress by this enhanced standard of proof. Clear and convincing evidence, okay?
And I don't know why the state doesn't argue inevitable discovery more often, because it's so many of my cases where I'm arguing for the suppression. I keep thinking, if they argue inevitable discovery, I'm dead.
Yeah,
it's clear they're going to win, and they never argue it. They never argue it, and yet it's clear as day. If I was the prosecutor, I'd argue it. I wouldn't care about the consent or what. I'm going to go with inevitable discovery no matter what. And the truth is, most of the time, they would have seized the house or the car, and they're going to search it later on, right. Inventory search, whatever. They're going to inevitably discover it.
Yep. Now that really kind of puts us to where we are today as a practical matter, and just the knockdown, drag out, municipal court, superior court motion practice. I want to kind of spend a couple seconds to figure out how we got to where we are today, okay? Because there's been some significant changes in the law, both in federally from a recent case at the end of this term, and 2 New Jersey Supreme Court decisions that are both shrouded in mystery for reasons which we'll tell you about in a few moments. That's very interesting. I haven't been able to get to the bottom of it, but I'm working on it. All right, let's go through the law in a chronological sequence, federally first, and then we'll talk about it in New Jersey. The exception of the warrant requirement for consent was first discussed by the United States Supreme Court in 2 World War II era cases involving searches by the FBI, involving black market type searches by people who were selling gasoline and cigarettes and things of that nature during the time period. Davis and Zapp, they both say the same. In fact, their companion cases are published on the same day. And all that comes out of these cases is a recognition that consent is an exception to the warrant requirement, and if someone validly gives a consent to a search, that the federal officers can conduct that type of search. Now remember, this is in an era before Mapp versus Ohio, so we're talking about searches limited to, federal type activities, okay? Now, by 1968, it had been established that when a prosecutor seeks to rely upon consent to justify the lawful search, he has the burden of proving that the consent was in fact freely and voluntarily given, okay? And you're going to see how this comes up in State versus Johnson in a moment in New Jersey. Precise question left unanswered prior to 1973 was what specifically must the prosecution prove in order to demonstrate that a consent was voluntarily given. This leads us to the landmark Supreme Court decision of Shinnecock versus Bustamante. And the question here is, when we talk about a consent search and voluntariness of a consent search, what does that mean? How do judges make a determination about whether or not a search was voluntary? So by extension, this case becomes critical for two different issues. One, a Fifth Amendment issue, and the other one, a Fourth Amendment issue. What the Supreme Court does is they take all of the rules related to voluntariness of a confession, all right, Miranda type stuff, take those criteria and apply them to the Fourth Amendment setting dealing with the voluntariness of a consent. So in a sense, you get kind of a double shot here that Shinnecock versus Bustamante is not only a seminal case for consent in the Fourth Amendment context, but it's also widely quoted as a seminal case for consent in the Fifth Amendment context for the voluntariness of a confession. Joey, could you read what the court says?
In determining whether a defendant's will was overborne in a particular case, the court has assessed the totality of all the surrounding circumstances, both the characteristics of the accused and the detail of the interrogation. Some of the factors taken into account have included the youth of the accused, his lack of education or his low intelligence, the lack of any advice to the accused of his constitutional rights, the length of detention, the repeated and prolonged nature of the questioning, and the use of physical punishment such as the deprivation of food or sleep. In all of these cases, the court determined the factual circumstances surrounding the confession, assessed with the psychological impact on the accused, and evaluated the legal significance of how the accused reacted.
In a very large extent, Joe, this is exactly what you're talking about the concept of what was going on in the mind of the defendant to see whether or not his will was overborne, the intimidating nature of the fact pattern that we were trying to make before.
Okay, now let's go back to that. Here, there are, you know, having been a former prosecutor, and when I'm not a defense attorney during the day, I'm a citizen at night who wants to see all the criminals caught and locked up and get the maximum sentences. Not during the day, but during the night. That's what I think when I read about some of these things or hear some of my friends' cases. But if you've had real confession cases, I mean, where there's real issues, where your client was interrogated for 8 hours, and there were 3 big, strong 220-pound, 240-pound detectives in their 40s questioning your 19-year-old defendant who came to America at 12 years old from Vietnam. And that's an actual case I'm talking about. And you realize that our courts, New Jersey courts, have ruled that you cannot bring in a psychologist who specializes in the field of the pressure on people who are in police detention and the subtle psychological influences on them, and determining whether or not the confession was given freely and voluntarily. It astounds me. They say every average juror can understand why people would falsely confess to a crime that they didn't commit. They said the average juror could understand that. Really? Talk to your neighbors and friends and say, look at this guy, had a 23-page stenographically recorded and signed confession. But he really didn't mean it. They go, well, get out of here, that's bull. None of them would believe that. But we do know that in the Innocence Project cases, where the people are on death row, that just statistically, where courts have absolutely said, due to the DNA evidence, they know it clearly wasn't this defendant and he's freed, that 1/3 of them gave confessions.
Joe, can I ask you a question about another Bergen County catastrophe? I think this came out of Oakland. It was State versus Gookins. Do you remember that case?
Gookins.
Yeah, and what was happening in Gookins is the cop was hitting these people up for bribes. And when the people, you know, wouldn't pay the bribe, you know, he would make false evidence against them. And what was shocking to me were 2 things. First of all, that the appellate division didn't throw out all these convictions. They actually had to go to the Supreme Court. But more importantly, how many of those people pled guilty when they were factually innocent? They've been subject to bribes, you know. Why did they plead guilty? I just have never understood that. And there was a lot of them.
Sure, because a lot of the people felt by paying a bribe that they committed a crime, even though it was induced by a police officer. And the second reason I really believe is it's the same reason why our Supreme Court, under court rule, so easily and universally says judges, municipal court judges, should grant civil reservations, because they say a lot of people plead guilty simply because it's just easier to do that than spend the time and effort sitting around in municipal court 1, maybe 2 days. And, you know, I'll just plead guilty to the ticket even though I'm innocent of it, because I just don't want to waste my time. And I think it comes down to those 2 things. The significant fact about all these decisions is that none of them turned on the presence or absence of a single controlling criterion. Each reflected a careful scrutiny of all the surrounding circumstances. In none of them did the court rule that the Due Process Clause required the prosecution to prove, as part of its initial burden, that the defendant knew he had the right to refuse to answer questions that were put. While the state of the defendant's mind and the failure of the police to advise the accused of his rights were certainly factors to be evaluated in assessing the voluntariness of defendant's responses, they were not, in and of themselves, determinative.
Now, just to give you a setup here, you're going to see two things of significance. Number one, the United States Supreme Court is now going to establish the totality of the circumstances test in consent searches, okay? And number two, they are specifically going to say it is not necessary for the state to demonstrate that the person knew he had a right to refuse. Exactly the opposite of what's going to happen in New Jersey. Take a look.
Similar considerations lead us to agree with the courts of California that the question whether a consent to a search was in fact voluntary. Why they need to put that in quotes, I do not understand.
There's no such thing as a voluntary.
Oh, that could. This is a mythological creature. Yeah. It's similar to the unicorn. Whether a consent to a search was in fact voluntary or was the product of duress or coercion, express or implied, is a question of fact to be determined from the totality of all the circumstances. While knowledge of the right to refuse consent is one factor to be taken into account, the government need not establish such knowledge as the sine qua non of an effective consent, assuming that the defendant understands Latin. As with police questioning, two competing concerns must be accommodated in determining the meaning of a voluntary consent: the legitimate need for such searches and the equally important requirement of assuring the absence of coercion.
Now, what you're going to see, when we get into the New Jersey case in State versus Johnson, which I think was 75, was our Supreme Court, for the first time in the history of our state, at least under the 1947 Constitution, decides to depart from a holding of the United States Supreme Court. Because prior to Johnson, all of the state constitutional doctrine and Fourth Amendment doctrine were identical, okay? They were, I forget what the word is, coextensive, I think is the word they used to describe it. Johnson becomes the first of many, many subsequent cases where the Supreme Court says, no, we are going to depart from the federal precedent and offer more protection under our state constitution than people would be entitled to under the Fourth Amendment. You'll see Johnson's the case that's going to require knowledge, proof of knowledge as one of the elements the state's going to have to demonstrate by clear and convincing evidence, hence the consent to search form. Okay? You'll see that momentarily, but I just want everybody to understand the significance of this case, how it establishes this totality of the circumstances test for use in these consent cases, and how New Jersey takes this and moves it a step further under the state constitution.
Now, Bob, is that a result of these decisions protecting citizens' rights? Is that a result of the composition of our Supreme Court being left-wing liberals who are judicially legislating? I'm sorry, that was what Christie said the other day. I meant, please go on.
Double A, here's a case after you, State versus Matlock. This is probably a family member of yours. And this deals with the common authority rule. Now, this is where you get into a lot of cases, because when you're talking about consent, that's fine. You know, if somebody consents, you can conduct a search. But who gives the consent? Right? Who has authority to give the consent? And supposing the person who had the authority to give the consent really didn't have the authority to give the consent, you know? Is there a good faith exception to the warrant requirement in New Jersey that excuses the police under those circumstances? Well, let's get to basics. Let's talk about the common authority rule. Joey, could you read this, Matlock?
Sure. These cases at least make clear that when the prosecution seeks to justify a warrantless search by proof of voluntary consent, it is not limited to proof that consent was given by the defendant, but may show that permission to search was obtained from a third party who possessed common authority over or other sufficient relationship to the premises or effects sought to be inspected.
So Matlock stands for the proposition that consent need not come from the person who has, direct control over the area or thing or place to be searched. Someone else who has authority, either legitimate, legal authority or apparent authority, can authorize the cops to conduct a search, and that's perfectly okay. Once again, given the voluntariness of the search. And you're going to see how this comes up in about 4 million different contexts momentarily. 1990 was the next explanation of this apparent authority, dealing with a situation where the person who had the apparent authority it was only apparent because the person had no authority to do it, okay?
They did not have the authority of a parent.
They didn't have anything. Read that, Joey, could you?
We see no reason to depart from this general rule with respect to facts bearing upon the authority to consent to a search. Whether the basis for such authority exists is the sort of recurring factual question to which law enforcement officials must be expected to apply their judgment. And all the Fourth Amendment requires is that they answer it reasonably. The Constitution is no more violated when officers enter without a warrant because they reasonably, though erroneously, believe that the person who has consented to their entry is a resident of the premises than it is violated when they enter without a warrant because they reasonably, though erroneously, believe they are in pursuit of a violent felon who is about to escape.
So,
check out the name of the case. Stoner versus California. Dude, they were chasing me. Whoa.
So in Illinois versus Rodriguez, the person who gave the police consent to search the house lied to the police, saying that she had authority to be there and that she lived there with the guy. And it was actually, she hadn't lived there for months. Didn't even have, she had no authority to be there, no authority to consent to the search. Okay. But the police didn't know that at the time. It appeared to them that she was perfectly legitimate. She actually had a key to the place, which was evidence that, to them, as far as they were concerned, that she had a right to be there. She just is just a key that she had kept when they threw her out. So the police went in, conducted their search, grabbed all the evidence, and of course the argument is, well, she had no authority to grant consent here. The Supreme Court says it doesn't matter. The police acted reasonably because they took the steps, necessarily to kind of verify that she had authority to consent to the search. The fact that they were wrong, really doesn't matter. Now here's what's interesting, and we're going to see this in the New Jersey case law. Remember that there's no good faith exception to the warrant requirement. This is an exception to the exception. New Jersey follows the same rule. If the police are mistaken because the person lied or gave them bad information, and they conduct a search on faulty consent, it doesn't matter. The evidence is going to be admissible. New Jersey follows Illinois versus Rodriguez, okay? So they don't take into consideration this lack of a good faith exception in New Jersey, the state versus Novembrino. If the police act reasonably, although the information is objectively wrong, it's okay. The consent will be deemed to be valid in New Jersey. You'll see how that develops in a few seconds. This is one of the few times that they do this. Now, let's talk about some of the people who have authority. One comes up in the context of the hotel. The clerk behind the counter at the hotel, has no authority to enter, to police enter the guest room of a guest, okay? I mean, obviously he has authority to a certain extent in certain common areas of the hotel, but, your hotel room is your home. It is your castle. You're entitled to a very, very high degree of privacy, expectation of privacy in your hotel room. And this is just an individual who, while you're renting the place and living there, the clerk at the hotel does not have the apparent authority to grant consent for the police to go in and conduct the search. Here's the case on landlords. Chapman is the United States Supreme Court case. The New Jersey case is Skrotsky. And basically it says generally landlord does not have the authority to consent to a search of a tenant's premises. Same principle that you'd have behind the hotel clerk. They're kind of functionally the same. Now the landlord does have the authority to make his own entry into the place. Typically it's in the lease, or it would involve repairs or emergencies that come up where they have to go in and do something. There's a couple of fairly recent cases where the landlord went in to do a repair and while inside saw contraband in the form of drugs, and then called the police and kind of walked the police through there, and that was sustained by the appellate division. But generally speaking, though, if the police show up and want consent to search a particular room, the landlord doesn't have the authority to have the police go in and conduct that type of a search. Okay, Chapman and Skrotsky stand for that proposition. Older cases. All right. This is Georgia versus Joyce Randolph. Okay. And I'm going to give you the setup here. It's this case is so much fun to think about. Has anybody in here ever been married? No, I'm just joking. All right, I don't want to torture anybody. But imagine like you're having a fight with your wife, and like making a big racket, and the neighbors call the cops, and before the cops arrive, your wife is extremely angry with you, So you get the knock on the door, knock, 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 and the two of you show up at the threshold at the same time. And the cops say, you mind if we come in? And the husband says, no, you're not coming in. I don't want you here. And the wife says, well, I want you here. I want you to go up to our bedroom and get those drugs out of my house that he has. Get that cocaine out of here. And the husband says, you ain't coming in here. You know, as he pulls the old Jerry Garcia. You got a warrant? I guess you're coming in, right? No. You got a warrant? Come back with a warrant. Then you come in here. Forget about it. You're not coming in.
That's only if you're riding that train high on cocaine.
That's right. So you got two people standing at the threshold. All right? One says, come on in and grab those drugs, because she's pissed off. The other one says, I don't want you cops in my house. What are you supposed to do? All right? Well, let's take it out of the police context. If you're a person going over to see friends, and the two friends stand in the doorway, and one says, come on in, the other one says, stay out, what are you going to do? You're going to stay out. Everybody knows that. I mean, the Supreme Court knows that, all right? So since everybody in the world, just using like the little tiny bit of common sense, would stay away, you would expect the cops would do the same thing. But not in this case. What does this show about police? Too persistent. Too persistent, that's right. And too suspicious also. So the police decide, we're going in. So they go in, they recover the cocaine, charge the guy, and here we are. It's not Joyce Randolph. I just made that joke for the benefit of Joe. So what is the rule with respect to this, where you have two people physically there? One says, come on in, search by consent. The other one says, no, stay out of my house. Okay? Can you read it, Joey?
To begin with, Bob, it is fair to say that a caller standing at the door of a shared premises would have no confidence that one occupant's invitation was a sufficiently good reason to enter when a fellow tenant stood there saying, stay out. Without some very good reason, no sensible person would go inside under those conditions. Fear for the safety of the occupant issuing the invitation or of someone else inside would be thought to justify entry, but the justification then would be the personal risk, the threats to life or limb, not the disputed invitation. This case involves a straightforward application of the rule that a physically present inhabitant's express refusal of consent to police to search is dispositive as to him, regardless of the consent of a fellow occupant. Scott Randolph's refusal is clear, and nothing in the record justifies the search on grounds independent of Janet Rudolph's consent. The state does not argue that she gave any indication to the police of a need for protection inside the house that might have justified entry into that portion of the premises where the police found the powdery straw, which, if lawfully seized, could have been used when attempting to establish probable cause for the warrant issued later. Nor does the state claim that the entry and search should be upheld under the rubric of exigent circumstances, owing to some apprehension by the police officers that Scott Randolph would destroy evidence of drug use before any warrant could be obtained.
So take a look at the elements that you have here. The first one is to look at the presence. The guy is physically there, talking to the cops on the threshold of his door, okay? What do you do when the guy's not there? When he's been taken away, or he's some remote place?
He's at work.
Or, you know, but he's calling the cops up and, you know, yelling at them on the phone, stay out of my house, where the person who's physically there is saying, come on in and search for the drugs, okay? Also note the distinction here on domestic violence cases, okay? Because you could very frequently and easily have a domestic violence situation where the victim wants the cops there and the batterer does not, okay? That's a situation where the search is justified by community caretaking or by exigent circumstances or any one of a number of exceptions to the warrant requirement outside the scope of consent. But in the absence of domestic violence, when you have two people there and one saying yes, the other saying no, the objector is the one who kind of wins the day, so to speak, okay? Now, having said that, this kind of raises a whole bunch of factual scenarios that, you know, have to be determined by the court. At the end of this term, the United States Supreme Court had a decision which expounds upon Georgia versus Randolph. And there are two New Jersey Supreme Court decisions that follow from that. So the case we have to talk about first is the United States Supreme Court case from this term, Fernandez versus California, which is here. Joey, can you talk about Fernandez?
I can. Fernandez versus California was decided in February of this year, only just a few months after Randolph, Georgia versus Randolph. The the issue in Georgia versus Randolph was whether two occupants, co-tenants, if you would, could be husband and wife, boyfriend, girlfriend, just two people sharing an apartment, give consent. If they're both present and one of them says no, that one wins. The other one, even though they say, no, please come in, the police don't have the authority to enter when one of them objects. In this case, it's something different. In this case, the police observed a suspect in a violent robbery run into a building. So the police ran into this building, which was an apartment building with lots of apartments, and they don't know where the defendant ran. However, they do hear, immediately upon entering, almost immediately, they hear a woman beginning to scream bloody murder, scream for help, and one of the officers says, hey, I have an idea where he may have gone. So they go up to that apartment where they hear the screaming, and the knock on the door, and the defendant opens the door, and they say, we'd like to come in. And he says, no, you're not coming in. Stay the hell out of my apartment. They look over his shoulder and they see his girlfriend, whose face is all bashed in and bloody. It's hard for me to conceive because they talk about it in the opinion as if it was just a matter of a few seconds that he had time to beat her to a pulp within that period of time. I mean, she probably objected to him running into the apartment and having the police chasing him, but nonetheless. So the police look and they see him and he says, you're not coming in, you're not coming in. And they look at her and they say, could you please step out? They look at her and they decided she'd been the victim of recent domestic violence because she's all bashed and blue and bleeding. And so they place him under arrest and they escort him out. Now, an hour later they come back and they say, we'd like to search your apartment. And she says, come right in. I'd be very happy to because that SOB, I'm not going to continue the conversation, but if you have someone that can consent to enter your apartment and you have stuff in there you want to hide, do not beat the hell out of them because even an hour later they're still going to be pissed.
But Joe, he said to the cops, stay out of my place.
He did. He said, stay out. And he never retracted that. And it's his place. And guess what? When he said it, he was present with the co-tenant, his girlfriend. So both of them were present. He said, you cannot come into my place. So they say, I think he needs to be arrested and escorted out of here because he beat up his girlfriend. So they come back an hour later. She says, please come right in. And they find, although they didn't find anything really definitely related to the robbery, the opinion talks about how they found gang colors. And they found some bullets. And they found a knife. Well, okay, that's very interesting. And turns out they found stuff, but they didn't find anything really related to the armed robbery. Nonetheless, they were able to identify him as being in the armed robbery. And they seek to use that evidence against him at trial. And the court analyzes this. Remember, this is a little bit of a hybrid because he was present at the time when the police asked for permission to come in and he said no. They hauled his sorry butt off to prison to get him out. No, I shouldn't say to get him out of the way. They legitimately arrested him.
They had probable cause, right, Joe?
They clearly had probable cause. And whether or not they recognized him as the man running in from the armed robbery, the opinion doesn't say. Since they focus on the domestic violence, I guess they couldn't absolutely identify him, but he certainly resembled the person. So they arrest him and they take him away, and then they come back an hour later and the wife says, the girlfriend says, yeah, come on in and take a look around. So the court looks at this and they said, look, we don't like to handcuff the police. I mean, if there's evidence inside this home, the police should have the right to come in and take a look at it. If one of the people consents to it, it's in the best interest of society to catch and prosecute perpetrators of crimes from domestic violence to armed robbery. So when she says yes, they say, why should we not do it? And then the defendant says, hey, Parker, you know, Georgia versus Randolph. And the court said, you know, that's not the case because when she said yes, he was no longer there. He was gone. Since he was gone, it doesn't count. And of course, Mr. Fernandez says, whoa, whoa, whoa. I was there. I said no, and I never retracted that no, so that no stays in place. And the Supreme Court said a few things. They said, number one, yes, you did say no, but the next time you weren't there. And he says, I wasn't there because you arrested me. You wanted to go search my place, so you arrested me and you took me away. And that's why I didn't say no. That's why I wasn't there. It was your fault. You prevented me from maintaining my opposition to a consent search. And the court said, guess what? You were validly arrested. Now, if this had been a pretextual arrest, just to get you out of the way, that's something completely different. But this was a valid arrest. The police had clearly had probable cause, and they arrested you and took you away, and that was your problem. What they said is, a valid arrest equals absence of any reason. A valid arrest and you're taken off to headquarters is exactly the same as if you were at work or maybe playing with your child in the park or on vacation. You weren't home, we don't care why. There was a valid reason you weren't there. The consent of the wife is valid.
Let's take a look at what the court says. Police officers observed a suspect in a violent robbery run into an apartment building, heard screams coming from one of the apartments. They knocked on the apartment door, knock, 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 which was answered by Roxanne, you don't have to turn on the red light, Rojas, who appeared to be battered and bleeding. When the officers asked her to step out of the apartment so that they could conduct a protective sweep, Petitioner came to the door and objected. Suspecting that he had assaulted Rojas, the officer removed Petitioner from the apartment and placed him under arrest. He was then identified as the perpetrator in an earlier robbery and taken to the police station. An officer later returned to the apartment after obtaining Rojas's oral and written consent, searched the premises where he found several items linking the petitioner to the robbery. Trial court denied petitioner's motion to suppress the evidence, and he was convicted. Randolph does not extend to this situation, Georgia versus Randolph, where Rojas's consent was provided well after petitioner had been removed. Consent searches are permissible warrantless searches and are clearly reasonable when the consent comes from the sole occupant of the premises. When multiple occupants are involved, the rule extends to the search of the premises or effects of an absent, non-consenting occupant, so long as the consent of one who possesses common authority over the premises or effects is obtained. However, when a physically present inhabitant refuses consent, that refusal is dispositive as to him, regardless of the consent of the fellow occupant. A controlling factor in Randolph was the objecting occupant's physical presence. Now, dictum in Randolph suggesting that consent by one occupant might not be sufficient if there's evidence the police have removed the potentially objecting tenant from the entrance for the sake of avoiding a possible objection is best understood to refer to situations in which removal of the potential objector is not objectively reasonable, as Joe said, based on just a pretext. Petitioner does not contest that fact that police had reasonable grounds for his removal. In fact, they had probable cause, or the existence of probable cause for his arrest. He was thus in the same position as an occupant absent for any reason.
Now, here's the crazy part about their decision, the Supreme Court decision. They said two other things that I find risible. One is they said one of the reasons why the search was valid because even after she consented, if they went out and got a search warrant, whatever time it would take them to get that search warrant, well, she'd have to wait around, and that would trample on her rights to have the police officers enter her home. And furthermore, it would unduly burden and punish her because she has the right to a quick search if she consents to it. I don't see where that's in the Constitution. You have the right to a quick search. They can do it right away. But those are two of the reasons the Supreme Court advances.
Joe, you mentioned something a few moments ago, and it's so important that I really kind of want to talk about it. And it deals with the utility of searching for evidence, the public policy served by thorough police investigations. And the Supreme Court, the United States Supreme Court recognizes this by saying essentially, many times the police are working on an investigation, they don't have probable cause. They can't get a search warrant because they just don't have sufficient evidence to be able to get a search warrant. But they have, a basis for doing the search, just nothing that's going to let them conduct it by getting a search warrant. Consent becomes an extremely valuable tool to them in crime fighting and crime solving when they can get in and conduct their search in a consensual way. It's very valuable to society from a crime fighting standpoint that the police be permitted to do this, again, provided that all the rules are followed, that the consent is given voluntarily, knowingly, with an absence of coercion, okay? And Joe, I thought that there was such an important point that you touched on before. I wanted to kind of bring that out, that it's a substitute for situations, and legitimately so, in those areas where the police can't get a search warrant because they don't have enough evidence at this point. For the police to act, and New Jersey is different on this in the motor vehicle context, but for the police to ask for consent to conduct a search, the underlying basis for asking for consent is zero. They don't need to have any articulable level of suspicion at all. The only exception to that, and I think New Jersey may be the only state in the country that has this rule, is in the automobile context. We'll talk about this in the context of State versus Carty momentarily, where in order to conduct a consent search of a vehicle, the police first have to have a reasonable articulable suspicion that there's some type of drugs or contraband or criminal evidence inside of the car. But outside of the motor vehicle context, the police can throw darts. They don't need anything in order to ask for consent. They can have a hunch, a suspicion, or nothing. They just feel like doing it. If they get consent, they can search as thoroughly as if they had a search warrant. So, But your point is very well made. It is kind of like throwing darts under certain circumstances. Now,
Form for consent of a house?
what's that?
Do they need to have a form there or no?
Actually, State versus Johnson, which case that stepped this, was a search of a house. Okay, so the answer is yes. Well, no, let me retract that. The form is evidence. It's circumstantial evidence for the state. Okay? It's circumstantial evidence from which the court can draw an inference of the voluntariness and the knowledge that the person knew that he had a right to refuse. But it's not required. I mean, the state can rely on other types of evidence to demonstrate that the defendant knew he had a right to refuse. Either the police orally told him, or he acknowledged it to the police in some way that he knew he had a right to refuse. So it's just evidence. It's powerful evidence, but it's circumstantial proof. Okay, it's intended to let the court draw an inference of knowledge from that. Okay, it may be the guy doesn't speak English. The guy never read it. The cops made him sign it and didn't tell him what he was signing. It could be a million things associated with it.
Think about the Miranda form. Cops just have to give you your Miranda rights, but they have the Miranda form because that's powerful and persuasive documentary evidence. There's your signature at the bottom that you were given these.
It raises the inference in the mind of the fact finder that, you know, the guy did it voluntarily, knowingly. That's the whole point behind it. Now, there's a mystery going on here. I don't know what happened. Have you been able to make any progress in your investigation?
Well, we've investigated, and we have not found any reason why that these two cases, Lamb and Coles, decided just May 19th, have each been mysteriously withdrawn by the Supreme Court.
Yeah, let me just tell you, there is a little bit of history or precedent for this. We talked about State versus Dangerfield earlier today as a decision written by Justice Coleman. And when it came out, I remember reading it, and it was just wrong on the law over and over and over again. And I thought to myself, boy, the law clerk who wrote this must have been, he must have gone to Rutgers or something. I mean, just, you know, this is just awful stuff. And then apparently what happened was the Attorney General's office went to the Supreme Court. I don't know if they did it on the record or they went privately, but they said, look, you got to withdraw this thing. This is just bad, okay? So the Supreme Court withdrew Dangerfield, rewrote it, and then reissued it in its present form. So there is some precedent for them occasionally, very occasionally, withdrawing an opinion because of some technical issues. So they published Coles and Lamb, which are the two cases we're going to talk about now.
One was withdrawn, they said, quote, due to publisher's error. Does that mean it was not approved for publication? They thought it was?
No.
Who knows?
That's impossible because every Supreme Court decision gets published. They don't approve it. It just, they all automatically get published.
Well, it was withdrawn. One was withdrawn due to publisher's error, and the other one was just withdrawn.
So, as far as you know, Joe, has our Supreme Court reissued a redacted or amended version of these two cases?
The best I can tell you that this is, the versions I have are which are withdrawn, are the Westlaw versions as of last night.
Okay, so let's use these two cases because they're significant for the New Jersey view on Fernandez versus California. This is very, very fresh law. Remember, what was this, February?
No, these were May. This one was February.
Right.
Fernandez, and then 3 months later in May came the two Jersey cases.
So, but I want everybody to look at this with a little bit of a jaundiced eye because I can't tell you with confidence whether or not this is the final version of these decisions. It's a very unusual situation from the New Jersey Supreme Court.
And I don't believe they were shy and withdrawn. I think they were just withdrawn.
So what happened, Joey?
Okay, let's go to...
let's go to the videotape.
Let's go to videotape. Let's start with Michael Lamb. Michael Lamb is sort of the state version of Fernandez, the case that we just went through. And this case really, more so than any legal principle, is about the dangers of dating and the dangers of girlfriends. This is what this is really about. Now, Mr. Lamb was driving around a neighborhood, and his girlfriend was in fact driving. He stopped, pulled up next to a couple, a man and woman who were walking along, and said, "Look, we're looking for, Michael Jackson. Do you know where he lives?" "No, I don't know." The guy says, "I don't know Michael Jackson. I don't know where he lives. I never heard that name. Sorry, buddy." "No problem." A few minutes later, the car circles the block, comes back again. The guy says again to him, he says, "Look, I'm looking for this guy Michael Jackson. Do you know where he is?" He said, "No, I said I don't know where he is." His girlfriend says, "Sure you do. We know where he is." "Shh, shut up, bitch." And no, we don't know. And so Mr. Lamb, who's the passenger car, said, "You lying to me?" Whips out his gun, the poor passerby who didn't want to identify Michael Jackson, he runs over, grabs the gun, they're fighting for it, pushes it down in the car, and then he starts to run away, at which time Mr. Lamb takes out the gun and fires at both this man and his girlfriend, the girlfriend who started all this by, anyway. He luckily was not shot, and he rues the day the girlfriend wasn't shot too. Nonetheless, they run away. Now, Mr. Lamb, remember, we only catch the stupid ones. The reason we know it was Mr. Lamb, because they report to the police, yeah, some guy came here. Do you have a description of the car? Yeah, well, it was like a green Pontiac. You know anything else? Yeah. When he stopped the first time, he said, hi, my name is Michael Lamb. I live in this city, and I'm looking for Michael Jackson. So, sure enough, they look up the records, and Michael Lamb lives in that city with his parents. So he identifies himself before he decides to shoot these people. Look, if you're going to identify yourself, you got to shoot to kill. You can't just scare them. You can't wound. You got to, from that point on, you got to be committed. That's the problem with America. No one's committed today. They take half measures. Where's that old American spirit?
Joe, is there any additional inference to be drawn from the fact this occurred in Salem County? I mean, is there any
witchcraft? Yeah, who knows? This is so. Anyway, Michael and his girlfriend head back to his parents' home in a trailer park, and now the police. They said, well, we know that he lives here. We know his mother lives here. They drive around. They see the exact car that was described by the two attempted murder victims. And they said, okay, we got it. So they get the other cops there. They go up and they knock on. As they approach, they see the two homeowners are the defendant's mother and her husband, and his stepfather. So his mother and stepfather live there. So when the stepfather sees the cops coming, he just kind of moseys on into the house, closes the door. And the police could have just hooked up a truck and hauled the house down to the head station, but they didn't do that. That would be a good way of effectuating arrest. Yeah, they were all inside, locked inside, so we just hauled off their trailer. But anyway, so the police keep knocking on the door, and so finally the stepfather yells, get the hell out of here, cops. I don't want no cops here. You get off my property. You're not coming in here. I want you off my property. And he screams this the entire time. And he screams it after they come to the door. Ultimately, he comes to the door, and he tells them face to face, get off my property. You're not coming in here. I reject any right for you to come into my home. The police look over his shoulder, and then they see Mr. Lamb's girlfriend. Remember, the other girlfriend already caused problems for her boyfriend. They see the girlfriend, and they go, she seems to match the description I was seen driving a getaway car. So I said, we'd like to talk to her. And he says, you're not talking to anyone. She approaches the door. They take her by the arm, and they lead her aside, and they have a conversation with her. Now, look, she's different. She's dating this, gangster kind of guy. So she knows better. They say, do you know anything? She says, yeah, we were there this morning. I was driving around. He had a gun. He's shooting at people, Oh, thanks. Here's the second guy done in by his girlfriend, the dangers of dating. So she says, oh, yeah. And he says, well, do you have any idea where he is now? Sure, he's hiding under the bed in the bedroom. Literally. Does he have a gun? She says, could be. I don't know where the gun is. It could be in there with him. Okay. So now Mr. Marcus is the defendant's father, his stepfather. He says, you're not coming in here. You're not coming in here. No, there's a dangerous gun. We need to escort you away. We need to evacuate all the houses around, the trailers around here. And they do that. And the easiest way to evacuate a trailer park is yell, tornado. Because we know that tornadoes are attracted, apparently, to trailer parks. Every time I see a tornado story on TV, trailers are thrown all over the place. So they find trailers. There's like a magnetic attraction. So they empty all the other trailers, and they tell them, look, for safety purposes, we're evacuating this area. Mr. Marcus, you got to go. Come on, Mr. Marcus, you got to go. Come on, you got to go. We'll lead you away. Mrs. Marcus, he's gone. Could we search you? Oh, yeah, come on in. You can search, Now, Mr. Marcus is offered to go. I said no, but he's 100 feet away, 150 feet away. I said, no going in there. But he was not physically present in the doorway. He was 150 feet away. So I said, whoa. Rules don't have any effect when we're dealing with police officers because Constitution is difficult. There's so many cases. We believe that rules need to be simple. So we're going to say, unless he's there in the doorway, he's not there. This way we don't have to get into whether, well, if he's on the sidewalk, does that count? If he's in the yard, does that count? If he's at the neighbor's, does that count? 150 feet away, maybe, should it be a mile? Should it be 100 feet? We're just going to say, unless he's standing in the doorway, he's not present. One person gave consent, and And then they were allowed to search, and everything they found, including the defendant and what he had on him, that all comes into evidence. And now the defendant's argument was, whoa, Jack, whoa, you got to understand. They arrested my stepfather. I mean, they moved him out under some pretext in order to get my mother to consent. Now, the mother was really mad at him. She says, I'm angry at him because he's bringing a gun into my house, and he's out committing crimes, and he's coming back here, so yeah, you can go in and search. Later on, she denied, and she said that she felt intimidated by what we've already discussed, the fact that they said, look we got the house surrounded. We'll go and get a warrant, if we have to. She says, no, you don't need to get a warrant. And I don't want you coming in and searching, because if you come in and search with a warrant, you're going to tear up my house. And this is my brand new trailer. We just got it. It's a mobile home. I don't want it destroyed. So just come in. He's in the bedroom. Go arrest him. And they did. And they didn't tear up the house. And it was all very polite. So in the court in making this decision said, look, is this a Randolph situation where one of the homeowners initially stood in the doorway and said no, and then the police let him away? Was that pretextual? They said, we're not going to reach that. We're just going to say he wasn't standing in the doorway. Later, when they went back and asked the mother, because we had him off sequestered to the side for his own safety, and they allowed the search. Now, the other case is Mr. Coles. Now, Mr. Coles, this is an unfortunate reality of life. There was a violent armed robbery in Camden, and the description was very, very particular. They said it was a black male wearing a hoodie. Now, that hardly applies to anyone in Camden. So they find Byseem Coles walking down the street one night, just walking home, walking towards his house. He's about 4 or 5 houses away. And the police say, look, there's a black guy in a hoodie. Probably him. All right? So they go over and they say, who are you? I'm Byseem Coles. Where are you going to? I'm going home. I live in that house up there. Where are you coming from? I don't know what he said, because they didn't report it, but they said it seemed fishy where he said he was coming from. So they decided to do a frisk and search, a search incident to this investigatory field stop, because they know that the person charged had a gun. So they search him. They find none of the proceeds of the robbery. They find no guns, no weapons, no drugs, nothing. So they said, show us ID to prove that you're Byseem Coles. I just went out for a walk. I don't have any ID. Okay, we're going to detain you till we can identify you. So he said, but that's my house right up there. Everyone there knows me. I'm 4 houses away. Okay, you sit in the patrol car. We're going to go down and we'll ask. So they go down and they say, do you know Byseem Coles? Yeah, he lives here. Could you describe him? Yeah, he's my family and he's got a hoodie on. Is that him over there? Yeah, that's him. We'd like to search his room. Okay. Sure, what's the problem? We'd just like to search his room. So they search his room and they find some material, obviously, for which they prosecute him. Now, Mr. Cole's response to all of this is, whoa, what's going on here? I would have objected. I had stuff in my room I didn't want them to find. But they kept me 4 houses away in a police car for no friggin' reason. Because they wanted to need to prove who I am. Why do I need to prove who I am? I hadn't done anything. They had no evidence I was involved in a robbery for the initial stop. Sure, maybe the initial stop was okay to question me. I roughly approximated the description of the person that was involved. But after that, when they found nothing on me, oh, I forgot to mention, they brought the victim of the armed robbery to ID him and said, I don't think so, I don't know. It doesn't look like him. Okay. And they found nothing else on him. Nothing, no contraband, nothing.
Guilty.
Yeah, that's the point. You talk about, if you think we're done with racial profiling in this country and in this state, Lord have mercy. Anyway, so his argument was, I was prevented on a pretext from going back there. I would have objected to the search of my room. I wasn't doing anything wrong. Sure, I had bad stuff in my room, but I wasn't doing anything wrong that night, and they didn't have the right to do this, and they kept me in the police car just so I could go there. And the police said, no, we were trying to get his identification. That's why he was still in the police car. And the court said, seriously? Why did you ask to search his room? If you didn't think he was Byseem Coles, and you were looking for Byseem Coles' room, why did you say, we want to search his room, pointing to the car? You acknowledge in doing that he lived there, that was his room, and therefore he must be Byseem Coles. You now had his identification. This is all pretextual, and the court found, indeed, this was a pretextual stop, for the purposes of allowing someone else who had common authority over the premises to search his room. Now, Justice Patterson alone dissented on this, and you know, you all understand the theory, the pretextual stop. You know, we'll make up a situation to keep the defendant who would legitimately want to object from being in a position where he could object, so we get to go in and search. Justice Patterson said this was inconsistent with Randolph, not because she didn't mention the concept of pretextual stop or not. Justice Patterson basically said the following. This is distinguishable from Randolph because in Randolph, the defendant said no in the doorway and then was pretextually taken away. Here, the defendant never got to his doorway. He was pretextually kept from getting to the doorway. So since he was going to the house as opposed to coming from the house, this whole rule about pretextual arrest is not even relevant because he wasn't standing in the doorway initially. The other justices said, I don't think so, and it's a 6-1 decision.
You know, you stop to think about this exception of the warrant requirement for investigatory detentions. I mean, the whole purpose of a Terry stop and frisk is to allow the police a reasonable period of time to either confirm or dispel whatever their reasonable and articulable suspicion is. Okay, that's the whole idea. That's what's going on here. So the police they know there's been a robbery. They're, you know, the only clue they have is guy in a hoodie. Okay, a short distance away, and a short time later, they see a guy with a hoodie. So they stop him and detain him. How much proof do you have to for, you know, to develop a reasonable articulable suspicion? Again, it's just that much. No one is going to reasonably dispute the fact that the police had a reasonable and articulable suspicion to detain this guy.
And the defendant didn't. Even in court, he did not contend that.
So, what's their evidence? There's no weapon. There's no contraband. There's nothing to link him to that.
And no ID by the victim herself.
And the victim comes over for a show up and says, I'm not sure that's the guy. So how much more evidence do you need? Okay. At that point, I mean, just on this continuum, at some point the cops have got to say, this is not the right guy. We should have dispelled our reasonable and articulable suspicion at this point and send the guy home. But what's the problem with New Jersey police? Too suspicious, that's right. And, you know, they go back to the house to try to get this consent, get the consent from the mother for a guy that they're illegally detaining on the street. The police really should have just, when their suspicions were dispelled, just told the guy to send him on his way. It was the fact that he should have been let go. Once the police dispelled their suspicions, they were illegally detaining him while they went and got this permission from his mother to search his room inside the house. No, they had no legitimate authority to hold him. They should have just let him go home, and that's the end of it.
Yeah, now here's the scary part. They did say that there's a well-recognized right in New Jersey, even if you're just walking down the street at night coming back from a walk. I mean, have you gone out for a walk on a summer's night? Do you take your wallet and everything if you're just going around the block or something? Most people, I don't think, would. They said there's a reasonable right for police to detain someone who's not suspected of criminal activity after an encounter, if they can't identify themselves, detain them long enough so they can obtain an identification of who he is. I find that scary. That's a scary part of that opinion.
Now, each of these cases represents an iteration of Fernandez versus California, coming very, very close on the heels to the publication of the case. We're talking about a matter of 3 months. That's why it's important that we wanted to bring this up so you could get the New Jersey view on this. Just our closing minutes, I want to take a couple of seconds to review the New Jersey view on this, so when you write your briefs, you'll be able to substantiate the legal points you're making. Let's start off with State versus King. This is the case that establishes the enhanced burden of proof in consent search cases. Okay. General principle of law which governs the issue are well settled. When an accused consents to a search of his premises, he relinquishes the Fourth Amendment protections which prohibit unreasonable searches and seizures. Implicit in the very nature of the term consent is a requirement of voluntariness. To be voluntary, consent must be unequivocal and specific and freely and voluntarily given. The burden of proof is on the state to establish by clear and positive testimony that the consent was so given. Okay? So, when you're arguing in this, you're writing a brief, and you're going to hold the state to the burden of clear and convincing evidence, you'll cite State versus King. It's a case that stands for that proposition. The judge, municipal court judge hearing this may not be aware, or the municipal prosecutor may not be aware of the enhanced standard of proof. Here's Johnson, and I told you that this is the first instance in the history of our state where a Fourth Amendment issue was decided under Article 1, Paragraph 7 of our 1947 Constitution. This is the case that sets the requirements for voluntariness, and I told you they depart from Shinneckcloth versus Bustamante here by requiring proof by the state that, and this has to be by clear convincing evidence, the defendant knew he had a right to refuse to give his consent.
We conclude that under Article 1, Paragraph 7 of our state constitution, which is the Fourth Amendment, our version of the Fourth Amendment, the validity of a consent to search, even in a non-custodial situation, must be measured in terms of waiver. That is, where the state seeks to justify a search on the basis of a consent, it has the burden of showing that the consent was voluntary, an essential element of which is the knowledge of the right to refuse consent. Many persons, perhaps most, would view the request of a police officer to make a search as having the force of law, unless it is shown by the state that the person involved knew that he had the right to refuse to accede to such a request. His assenting to the search is really not meaningful. I threw in really. One cannot be held to have waived a right if he was unaware of its existence. However, in a non-custodial situation such as is here presented, the police would not necessarily be required to advise the person of his right to refuse to consent to a search. Our decision is only that in such a situation, if the state seeks to rely on consent as the basis for the search, it has the burden of demonstrating knowledge on the part of the person involved that he had a choice in the matter.
So there's no requirement that there be a written consent to search form as a waiver. Again, the state has all types of different evidence that can introduce on this issue, but it is an issue and it has to be proved by clear and convincing evidence, okay? Please be mindful of that. And note the significance of this Johnson case. This is really the first in a flood of decisions, first in the Supreme Court and later from the Appellate Division, where we depart from the United States Supreme Court on Fourth Amendment issues. Maristi deals with motor vehicle drivers. You get this in the motor vehicle context. Who is the person who has the apparent authority to consent to searches? This gets very, very complicated because, you know, right off the bat, it's the driver that normally is going to be presumed to have the authority to grant the search, okay? What do you do in a situation, though, where the officer opens up the trunk as part of the search and sees a bag in there that has somebody else's name on it, and that's a passenger in the car? Does the consent of the driver carry over to the luggage? What does this say, Joey?
To determine the constitutionality of a search and seizure, we consider whether the conduct of the law enforcement officer who undertook the search was objectively reasonable. Appearances of control at the time of the search, not subsequent determination of title or property rights, inform our assessment of the officer's conduct.
And Joe, just stop for a second. So if the police are wrong, it's not going to matter. I mean, this is the good faith exception business that we don't have in New Jersey. It doesn't make any difference. Here, if the police are wrong, as long as they were reasonable in attempting to figure out who was giving consent, it's going to be sufficient.
Yeah, a lot of times a bang-bang play at first base. The umpire reasonably concludes that the batter got there first. On replay, where they get it down to 1,000th of a second, they see he didn't. But his judgment in human time was reasonable. He may have ultimately been determined to have been wrong, but no one would argue that his initial judgment that the batter was safe was unreasonable. A warrantless search is per se unreasonable unless it falls within one of a few well-defined exceptions. One well-established exception is a search conducted pursuant to consent. To justify a search on the basis of consent, the state must prove that the consent was voluntary and that the consenting party understood his or her right to refuse consent. Consent may be obtained from the person whose property is to be searched, from a third party who possesses, just as we talked about before, common authority over the property, or from a third party whom the police reasonably believe has authority to search. Remember, the only thing that's forbidden in our law is unreasonable search and seizures, and if the police act reasonably, by definition, it's not unreasonable. Absent evidence that the driver's control over the car is limited, a driver has the authority to consent to a complete search of the vehicle, including the trunk, glove compartment, not the trunk, and other areas. But there's also a companion case.
Suazo, yeah.
Yeah. Which says, Suazo says the following: in the absence of evidence of joint access to or control over property found in the vehicle, a driver's apparent authority to consent to a search of the car does not include the authority to permit a search of the personal belongings of other passengers.
So you got a situation where the driver says, yeah, you can search the car. Okay? There's bags in the car. duffel bags or whatever. And the cops go in and start searching these duffel bags, all right? It's perfectly valid, okay? But if the duffel bag has a name Joe Schmo on it, you know, or a piece of luggage or something like that, which clearly it belongs to another individual, either someone who's in the car or not in the car, that's a different situation. You know, you'll need a different container, especially if the person who owns that has an expectation of privacy in the luggage or bag, whatever it is there. You really have to get that person's consent to conduct a search of that particular bag. Now, this is, I just really want to stress, this is an enormous exception in New Jersey law, where it says consent may be obtained from the person whose property is to be searched from a third party who has possessed common authority, or from a third party who the police reasonably believe has authority to consent, meaning the cops can be wrong. And it doesn't matter. This flies in the face of the lack of a good faith exception in New Jersey. This is a situation where good faith counts. If the police exercise good faith and reasonably believed, even though they're objectively wrong, you know, that this guy had the consent, it's going to be okay. This is a very, very narrow exception to the Novembrino rule. Yes, sir.
Yeah, this just steps out of the.
I hope you're not mad at me for giving that bad advice.
Well, I'm still going to look at it.
All right.
Although this steps out of the consent area, since it's the U.S. Supreme Court that can carve out search exceptions under the Fourth Amendment.
Yeah, they're the only ones you can.
Right. I see very often in local courts where the police, without consent, where they have a driver who can't find the credentials, decide to go into the glove compartment because that's an area where those documents are usually kept.
Yeah,
Has there ever been any Supreme Court Fourth Amendment?
Can I talk to you about it for a second?
Yes.
All right. The case on this is a case called State versus Boykins. It's a Supreme Court case. It's in 50, New Jersey. And the Supreme Court said at that time that the police, when the defendant can't find like his registration, the police are allowed to go in and conduct a search in the areas where the registration might be held, the visor, the console, you know.
Glove
usually
compartment, those three areas clearly.
Usually they can't go into the engine block, you know, to find the registration.
But they can tear the door apart because that's where I keep my registration.
Now, there was a case that was a decision written by Justice Venero right toward the end. Actually, it was one of his earliest cases. The name escapes me for a second. But basically, he held in this case that there is no Fourth Amendment document exception to the warrant requirement. Lark, State versus Lark is the case, L-A-R-K. And Justice Venero, writing for the court, says, look, there is no exception to the warrant requirement that allows the cops to go in and search for documents, okay? They just can't. In this particular case, the police went in to help the guy find his driver's license and found drugs. So I thought, and when I was teaching the police academy, I told the cops, don't be searching for credentials anymore because of Lark. And then Peña Flores comes along, and Justice Long says that the police were perfectly justified in going into the car and searching for the guy's registration, and that's where they found contraband. So I wrote her a letter, and I said, you know, you don't even have a reference in here to State versus Lark. Is it your intention to change the law, or did your law clerks miss this? And she wrote back to me, and she said, we mean what we say, and we say what we mean. I said, well, whose son is Popeye? I mean, you know, what are you talking about?
I am what I am, and that's all what I am. I'm Popeye the Sailor Man.
So, the answer to your question is, I don't know. I mean, I guess based on Peña Flores, yeah, because this Boykins case that they talk about seems, because they cite Boykins, but I thought the Boykins had been overturned by this Lark case. So, you're asking a very, very good question. I think the law is kind of undecided at this point. I would certainly litigate it if I had the opportunity to, because you have kind of a split in the Supreme Court.
You don't have to do it seriously. Do it on a lark.
All right, everybody cool with this? All right, here's Crum, and this is again one of these apparent authority cases, but dealing with parent and child. You get this with these little monsters, these teenagers, you know, who have like these posters of Kurt Cobain, you know, on their wall. I mean, these are things you should be suspicious of. They've got their door closed, but also have a padlock on the outside of it, you know.
That's bad parent.
That's right, and also the spring gun, shotgun inside the house. You know, that's telling you they have an expectation of privacy. So, question: to what extent does a parent have the authority to? I'm going to make a Joe Rem joke. At what point does a parent have a parent authority? Sorry, Joey, I apologize.
No, that's okay. Your delivery should be better though next time.
All right. Can you read this to everybody?
I can.
I'm ashamed of myself.
That's okay, we're ashamed for you too. New Jersey is among the overwhelming majority of courts holding that a parent has the right to consent to the search of the property of his or her son or daughter. Even in cases where the child has reached adulthood, courts have been reluctant to find that the son or daughter had exclusive possession of a room in the parent's home. This capacity to consent has alternatively been based on the parent's authority as head of the household or owner of the property, the exercise of parental responsibility over the child, or as a co-tenant or co-occupant, or codependent, depending on the family. Another factor considered in determining whether the child had exclusive possession of the room is whether the child paid rent for the room. An informal agreement that the child would pay rent when able to do so with no specified fixed amount has been held inadequate to give that child exclusive possession of the room. Cases which have upheld a parent's authority to consent to the search of the room of an adult son or daughter still living at home have turned on whether the adult offspring paid rent or utility bills and whether the parent had access to the room. Another consideration is whether the parent had ready access to the defendant child's room to clean it.
I think, again, these are fact-sensitive cases, but you start off with the age of the child. If you're dealing with somebody who's 18 or over, I think there's a different set of rules. When you're dealing with a juvenile, statutory juvenile, very, very, very low expectation of privacy. Even if they lock their room, the parents are still responsible for them legally and can consent to the police going in. If you're dealing with an adult, then you've got to look at these other extraneous factors. Were they paying rent? Was there a lock on the door? Did the parents go in there to clean? These types of things. Because, what's that?
Isn't that nonsense? The whole point of living at home is that you're not paying rent. And that's why kids can't move out, because they don't make enough money.
But that's why they shouldn't store their drugs there. That's the problem, because when the cops go in, well, you got to put it someplace where the cops are going to find it. They're certainly going to look in your room. Of course, it's inconvenient when you want to, well, never mind. So, anyway. No, I mean, listen, you're speaking the truth.
I'm 35, half my friends still live at home.
Get new friends.
What are your parents? Can you imagine how do you think as a parent when the kids come home, hey mom, dad, I'm here, can I move into your basement with my dog and girlfriend? All right, here's Cardi. I have to tell you guys, just if you'll give me a minute of personal privilege here. This Al Sharpton had a protest at the shore. This is probably 20 or 25 years ago on July 4th. There's some unbelievable holiday where everybody in the world's going to the shore, and he put a big protest march right across the Atlantic City Expressway with the express idea of shutting the highway down in order to just give everybody a hard time to protest racial profiling in New Jersey. And of course I was already at the shore, so I didn't care. I wasn't in the traffic jam, but I kept saying, get him, go, get him, shut it down, because I knew it happened. As a defense attorney, we knew it was going on all the time. It was so frustrating for us to see people getting stopped and searched based upon criteria that have nothing whatsoever to do with legitimate law enforcement tactics, but it just really had not been proven at that point. I knew it existed. I was happy that it was being addressed from a political standpoint, but I was waiting for the day that it would be addressed legally. Hardy, a decision written by Justice Coleman, is really kind of the recognition by the Supreme Court that racial profiling is real, it's going on, and State versus Johnson has failed to protect the motoring public from consent searches that are based upon pretext. The idea here is overwhelming numbers of minorities being pulled over and then being asked for consent to search when there was really no basis for the search at all except for racial considerations. And the court spends a lot of time talking about how people, just exactly as Joe was saying before, that people who are stopped are intimidated, they feel that they have an obligation to go along with the system, that the vast majority of people consent to the search because of factors that have nothing to do with guilt or innocence. They just feel intimidated by the whole process for reasons that Joe was saying. So the court recognized all this stuff and created a rule which at that time was unique to New Jersey. I don't even know if any other state has picked up on it at this late date, saying that if the police want to conduct a consent search of a motor vehicle in New Jersey, before they ask for consent, they've got to have a reasonable and articulable suspicion that there's some type of contraband or criminal evidence, fruits or instrumentalities of crime inside of the vehicle. Okay, that's the basis for asking for consent in the first place. Now, please be mindful of the following things. Number one, CARDI applies to motor vehicles and motor vehicles only. Once again, Joe's favorite case, State versus Domich, stands for the proposition that it doesn't apply in houses or other things. It's a prophylactic rule, as explained by the Supreme Court in Domich, intended to stamp out consent searches that are basically a product of racial profiling. A case called State versus Elders also expands upon this issue, indicating that the consent applies not only to vehicles that are moving around on the highway, but also disabled vehicles. The case in the Elders case, the vehicle had been broken down and was incapable of being moved. In fact, the people who were in the car were actually working on it on the side of the highway when the troopers rolled up on them. So it's a very, very important case which was intended to stop the police from engaging in an activity that really was a black eye for our state and for the state police. It led, as you may recall, to a consent decree and monitoring of our state police for a significant number of years. There was actually a kind of a assistant director of the AG's office who was kind of the interface between the state police and the U.S. Attorney's office to make sure that the requirements of the consent decree were properly handled. I think that this consent decree has since been dissolved, with everybody satisfied that that practice has stopped, at least from a state police level. I don't know to what extent, if any, it's being addressed on a local level.
Wasn't it just in the last year that they...
It's been fairly recent, Joe.
Yeah.
We were under it for a long, long time. So there's CARDI. And here's the citations I gave you. Domich, I mentioned to you before, again, clarifying that it only applies to cars, not houses, safes, searches, and things like that. And there's Elders dealing with the disabled vehicles, okay? So, we've tried to bring you up to date. I'm hopeful that what we've told you about the Coles and Lamb case, it sounds like a pretty good dinner. How about lamb over coals? We'll kind of bring you up to date on consent searches. These are very, very common, and especially with the state police, because this is the SOP they've adopted following the Peña Flores decision, okay?